Good morning. Today is Thursday, February 2nd, 2023, also known as Groundhog Day, which is kind of appropriate because the Affordable Heat Act had certain resemblance to a bill we talked about about a year ago. So with that, I'd like to, we're going to be working this morning on S5, and we've invited guests in the room to help us look at the bill from a legal perspective. So good to see you again, Mr. Tam and Ms. Murphy. I'll turn it over to you to help us look at the bill from a legal perspective. Questions and we have to share with us.
Great. Good morning, Mr. Chairman and Senators. Thank you for having me back. My name is Jeff Ham. I'm an attorney. The agenda says Dunkiel Saunders. We actually just yesterday changed our firm name to Saunders Rob Vogel on Hand, SRH Law. So I need to make sure I'm saying it correctly. It's the first time I'm saying it in public. But we're still doing the same sort of work. We were involved last year with the Clean Heat Working Group. They asked us to do a legal analysis of their proposal. And we prepared a memo that was presented last year on that proposal. I've reviewed the bill this year, which, as the chairman said, is similar with some important additions to last year. We haven't updated our legal analysis memo, but I think the general conclusions in that memo hold, and I'm going to walk through some of the sort of high-level principles for the committee to have in mind when they're looking at the law. I do want to say I'm not here testifying on behalf of anyone. We provided the review on a pro bono basis, not representing the clients, just here really to provide some perspective and be a resource to the committee on some of these issues that they can be thorny sometimes.
Thank you very much. We get an awful lot of work done by people volunteering to help it.
Yes, well, we're happy to contribute to this. So just a quick summary here. I'm going to try to keep this brief, and Ms. Murphy has comments to provide as well. I'm going to do an overview both of the state jurisdiction and our perspective to regulate heating fuels and implement the Affordable Heat Act. I'm going to discuss a couple of federal constitutional limitations on state jurisdiction, namely the Dormant Commerce Clause, everyone's favorite thing to talk about, and preemption under the Supremacy Clause. And then summarize just quickly with a few bullet points for the committee to keep in mind, some guiding principles for designing the Affordable Heat Program with those doctrines. To start, I want to start by setting the table, understanding the state's authority to act, and then we'll turn to the federal side. Vermont, like all states, exercises authority as a sovereign entity within its boundaries. And we often refer to exercising those powers as exercising the state's police powers. And that gives very broad grant to the state to make laws to regulate for the public's health, safety, and well-being. Federal courts, importantly, federal courts have recognized regularly that a state's energy policy and regulation of the energy industry in regard to some is one of the most important functions of the police power. Bless you. And it's similarly well settled that states have a legitimate interest in combating the adverse effects of climate change on their residents. That was established in a Supreme Court case, Massachusetts v. EPA. So in this area of state police power, the state can act, and the state has acted in this area quite comprehensively. Just as background, I want to touch on some of the statutes the state already has regulated heating fuels. So some of these will be familiar to you, some of them more important than others, but the state regulates the sulfur content in heating oil already. It requires licensing fees for petroleum cleanup on bulk heating fuel. There's a tax on heating oil and propane for weatherization initiatives. The AG's office has a very extensive consumer protection rule for propane dealers. And the state also has, although I don't think it's ever been implemented, a strategic oil set-aside. Like the Affordable Heat Act, all of these programs apply to voluntary commercial transactions where someone is reaching into the state to sell a product in the state. And that's an important thing to keep in mind. I left one important piece of legislation off of this list. I don't know if anyone, this is a pop quiz, I don't know if anyone knows what it is. The Global Warming Solutions Act. So I want to note that just in this context, the state already has mandatory limits on carbon emissions. We've set mandatory standards for reductions to be achieved by 2025, 2030, and 2050. That applies to all carbon emissions, including emissions from thermal sources. So although there's not a specific program, and that's part of what this bill is designed to implement, it is regulated already in the concept that the state must take action at some point to address reductions in carbon. And it's important to keep in mind that significant progress has been made in many sectors, including on the electric side, on reduction of carbon. But thermal and transportation, we really have not made as much progress. When we're thinking about the carbon reductions that need to be achieved, we need to see a lot of those in those areas. And one other principle just to keep in mind as we go through this, if we need to accomplish those reductions, it's much better to do that in a well thought out, planned out program that's implemented in advance, rather than trying to implement a program right up against the deadline that may be much more blunt. You may not have the opportunity either to make sure the program is well designed to accomplish policy needs and meet the legal limitations, or make sure that you're passing the benefits of that program along to the appropriate people. And this design bill has some very important provisions with respect to benefiting low and moderate income Vermonters. And I think it's valuable to have the time to make sure we're implementing that correctly before the deadlines in the statute are upon us. So just some context there. In our system of state and federal government, we often refer to it as cooperative federalism. The state has certain authority to act, but that authority is limited by the federal government's authority, which is superseding. And as I started at the beginning, there are two principles, I think, for the committee to have in mind that are relevant to this bill. The first one is the Dormant Commerce Clause. That stems from the Commerce Clause of the Constitution, which gives Congress the power to regulate commerce with foreign nations and among several states and with the Indian tribes. Now, implied in that express grant of authority to regulate commerce is an implied restraint on the states to unjustly discriminate against or burden the interstate flow of articles of commerce. And that implied limitation is what's referred to as the Dormant Commerce Clause. So it's a corresponding limitation to the federal government's ability to act very broadly here. And the primary concern of the Dormant Commerce Clause is to prevent economic protectionism. That is, it's a regulatory mechanisms designed to benefit in-state economic interests by burdening out-of-state competitors. So it's important to keep that in mind when you're thinking about how this program is designed. When you're looking at the Dormant Commerce Clause, courts will typically ask three questions. Does the law discriminate between in-state and out-of-state interests? And that is looking at whether there's a differential treatment of in-state and out-of-state economic interests that benefits the former and burdens the latter. That can be facial, or it can be demonstrated in the purpose and practical effect of the statute. Second question is, does the law regulate commerce occurring entirely outside of the state? We think of this as the extraterritorial application. It's not appropriate for a state to apply its laws outside the boundaries of its state, which makes sense. And then finally, does the law impose a burden on interstate commerce that's clearly excessive in relationship to the punitive local benefits? This is often referred to as the Pike balancing test. It comes from a Supreme Court case starting with the name Pike. And if we reach this point, it really is a very discretionary balancing test. And I'd say most statutes that reach that part of the analysis are typically upheld. I want to turn now just to a couple of examples of very similar programs that courts have evaluated already, similar to the Affordable Heat Program. One of them, as you all may be familiar with, is the California Low Carbon Fuel Standard. That sets a standard to reduce greenhouse gas emissions attributed to the fuel market. Fuel blenders are required to keep the average carbon intensity of their product below the standard limit. And they generate credits based on that, which can be traded. And fuels are evaluated based on the life cycle emissions to create those tradable credits. That program was upheld in 2013 by the Ninth Circuit Court of Appeals. They found, importantly, and I would underline this, I have in the presentation, but also for the committee, that distinguishing between different types of fuel products based on the carbon intensity of the product does not violate the Dormant Commerce Clause. That's a proper exercise of state regulatory authority to recognize and identify environmental concern. We need to address the impacts of carbon and climate change, and we're doing that through evaluating the relative carbon intensity or life cycle greenhouse gas emissions of each individual product. And those may be different depending on where it comes from, but it actually might result in scenarios where an in-state product is actually higher carbon intensity than something that's delivered from out of state if it's created and delivered in a fuel pathway that has lower life cycle emissions. So that's important to keep in mind. And also this court case emphasized that creating this kind of program is not the state acting outside of its jurisdiction, but rather it's structuring its internal markets to make sure that products that are sold and used in the state are less harmful to its residents. So very good case law on very similar grounds to what is being considered here. Just going to quickly touch on this one. Very similar, the Oregon Clean Fuels Program. You all may have had some testimony on this program as well. Very similar to the California program. I'm going to highlight just a couple of bullet points. They came to essentially the same conclusion about carbon intensity being the basis for evaluating products and that being appropriate. They didn't find any discriminatory purpose in the program, that the purpose was to reduce Oregon's contribution to global levels of greenhouse gas emissions. And importantly, they assumed that the objectives articulated by the legislature are the actual purposes of the statute. I did put one other bullet point on here just for the committee to keep in mind, that courts can look behind, on occasion, statements of purpose to see if there's an underlying intent. So if the conversation around this bill was, well, we really want to protect in-state providers of a certain type of resource, that's our purpose, it's an economic purpose, that wouldn't be appropriate. And that's not what I understand the purpose of this bill is, but I just want to highlight that as you're talking about the bill and its underlying intent, it's very important to be clear about the purpose of the bill. The last one I want to touch on here is the Connecticut Electric Renewable Portfolio Standard case. So as the committee is likely aware, there are a number of RTS portfolio standards around the US that relate to emissions from electric generating sources. This was a program in Connecticut that established a geographic boundary of the New England region and required utilities to have a certain percentage of electricity from renewable sources. That could include generating power itself or purchasing renewable energy certificates, sort of like the tradable credits are created here in the Affordable Heat Act. A developer who is outside of that geographic region challenged the statute under the Dormant Commerce Clause, and the program was upheld by the Second Circuit Court of Appeals, which found that the geographic limitations were appropriate, particularly when they're tied to the purpose of the bill. So in that case, the goal was to improve the air quality for the citizens of Connecticut. And I'd highlight this one as well, and also protect them from price and supply shocks that could result if, for example, in this case, there was a natural gas shortage. So looking at those benefits to customers, for example, of reducing their energy burden and protecting them from price shocks associated with fossil fuel products could be a legitimate intent as part of the bill. So that's the Dormant Commerce Clause. Let me stop there. Yeah, if there are questions before we talk about preemption.
Senator White and Senator McClung.
Thank you, Chairman Bray. Could you describe what a supply shock is? Like
Well,
what legally that means?
Yeah, I think in that case it's sort of a term of art, but it's similar to what we have experienced recently, where either the generating units don't have they either go down and there's a supply of electricity or a reduction in the supply of electricity. I think in this case, it's talking more about supply of natural gas not being available to generators. And in New England, we have a lot of natural gas base load power, and that could have the impact of dramatically increasing the price of electricity very quickly. So that was the context of this discussion. But it's an issue that I think a lot of folks are looking at in our current environment.
Just to follow up on that a little bit before going to Senator McCormick, is it a legally specified requirement that when there is a constrained natural gas in southern New England, that gas flow first to customers getting heat as opposed to using it for generating power?
Yeah. Yes.
By practice or by law?
I believe by law that the heating customers take precedent over industrial or electricity producers.
Where does the dormant part come in?
Yeah.
Essentially, the Commerce Clause is pretty upfront.
Yeah, it's the fact that the Commerce Clause says the federal government can't do this, but it's silent on the implied restriction on states. So therefore, states cannot do that. So that implied restriction is called dormant.
All right.
It's the sleeping part of the clause that you wouldn't necessarily see, but it's just as important. So the state, because the federal government can act in this space and has control, the state may not do something to interfere with interstate commerce. Does that make sense?
Okay, yeah. I'm thinking there are a lot of things the federal government does that the states do also.
Yes, and the concept of cooperative federalism is there are many places where those regulatory regimes interface, and we can talk about some of those in a minute, and where there's an opportunity for the feds to set a standard, but states to go above that standard. And you think about that as a good way to set the national floor, but we often talk about this in this context as states being the laboratories of democracy. You want to give the states the flexibility to act in areas they have authority in a way that doesn't step on the federal government's broader authority. And so that's the concept of cooperative federalism, that state and federal government should be working together in some of these places.
So the question of whether a state action violates the dormant part of the Commerce Clause is, are we interfering with the federal?
Yeah, the
We
three-part
have the right
test.
to do certain things,
You have
as long as they don't.
Right, you have the right to regulate commerce within your state, so long as that three-part test, if you're not doing so in a manner that discriminates against out-of-state interests and that appropriately balances the state interests in the state with the impact on interstate commerce. And some of those questions go to this next issue of the Preemption Doctrine, which is another federal doctrine, also comes from the US Constitution. And this is in Article 6, Clause 2, which says the laws of the United States are the supreme law of the land, and anything in the Constitution or laws of any state, the contrary notwithstanding. So that is, we just were talking about, establishes that federal statutory programs are supreme to state programs, and they take precedent and preempt state programs that interfere with them. There are two ways that you might find preemption. One of those is express, and so that would be if a federal statute says we are expressly prohibiting the state from acting in this area, or we are taking exclusive jurisdiction over this issue. And then you can also have implied preemption, and that is, there are two different types of that: field preemption or conflict preemption. Field preemption is when the federal program is so pervasive, there's so many federal statutory regulatory requirements that there really isn't room left for the state to act. Or conflict preemption, which is where there's a direct conflict between a federal requirement and a state requirement. We looked at this concept with respect to the Clean Heat Standard, and I think it applies equally to the Affordable Heat Act that you've all been reviewing this year. We looked in particular at 3 or 4 federal programs that you want to make sure this program is not running afoul of. The first one of those is the Natural Gas Act. That provides federal regulatory authority over interstate natural gas transportation. And and wholesale transactions. But importantly, it leaves states significant regulatory authority over the production and the retail distribution of natural gas. Essentially, wholesale interstate transactions are federal, in-state distribution activities of a natural gas provider are state regulated. And this program, we can talk about it in detail if you'd like, but draws an appropriate line of regulating, in this case, the natural gas distributor in the state utility at the distribution level, not interfering with its wholesale transaction activities. Similarly, we looked at the Clean Air Act that obviously regulates emissions from both stationary and mobile sources. And it relies, like the Natural Gas Act, on some cooperative federalism. There's space for both state and federal action. And in this case, states have significant flexibility to regulate stationary sources above the federal baseline. And in this case, we don't see any indication of any potential preemption conflict with the Clean Air Act based on the way this program is designed. Similarly, EPA's renewable fuel standard sets guidelines for increasing domestic renewable fuel production and reducing emissions. Again, very similarly to the Federal Clean Air Act, courts have held that stricter state renewable fuel limits are complementary to the goals of this program, so no conflict there. And then the last one that feels a little attenuated, but still worth thinking about, is the Energy Policy and Conservation Act, which among other things gives the U.S. Department of Energy the authority to regulate the efficiency of appliances building programs. And this, people often interact with this through the Energy Star program, which you see probably when you go buy a new washer or dryer. Again, nothing that we see in terms of the state's goals of pursuing installation of more efficient equipment through this program for the benefit of Vermonters would conflict with or be preempted by that program. So I thought I'd just circle back to a few sort of high-level thoughts before turning it over to Ms. Murphy. Based on those standards, a few boxes to check. You want to make sure the Affordable Heat Act is not discriminating based on the origin of products. And as we talked about, in this case, the program is designed to evaluate each clean heat measure based on its life cycle emissions, considering the full fuel pathway. And it's ensuring that decisions made about which measure to use are based on that analysis, not on the origin of the product or supply.
Thank you, Chair Gray. So just as a hypothetical example where we might do that, in your opinion, we've had constituents who have noted that they don't want out-of-state natural gas or out-of-state biomass. They want that to be called out explicitly, and the bill is not allowed. Yeah. That, based on what you've described, would not be something that we would be able to.
Creates more risk. Yeah, the strength of the bill as it's written is in its non-discriminatory nature of treating each clean heat measure on its face simply based on its life cycle emissions and not from where it comes.
Okay.
And I do think you would create some significant risk if you started to distinguish based on in-state and out-of-state.
Okay, thank you. That's really helpful.
So no matter what the intention was of the proposers of that,
Yes.
it could be seen as legal protection.
It could be. It could be interpreted that way as a court when it reviews it, for sure.
Well, I'm glad I asked.
Similarly, the program should only apply to jurisdictional transactions that occur within the state. And this is an important point. There was one program, I think it was an RPS program in a Midwestern state that was read to potentially apply to essentially transactions that were just passing through the state. So someone outside the state delivered something across the state, but not to anyone in the state, and to a provider outside the state. That was found to potentially violate the Dormant Commerce Clause. I think the statute, the Affordable Heat Act as drafted, deals with this appropriately in the way it designs and defines the obligated party. So it talks about the regulated natural gas utilities serving customers in Vermont. And then it talks about other heating fuels. The entity that makes the first sale of the heating fuel into or in the state for consumption within the state. So each of those clauses is important as you unpack them.
So that's an obligation on the seller in B, is that correct?
That's correct. Yes.
Senator Watson.
So when I see the or in there,
Mhm.
I also could envision it. I want to make sure that it's clear that it's not an and, if that makes any sense, because if somebody sells it into Vermont and then or in the
Yeah.
state. So there's the first sale that goes into the state
Yes.
or in the state for consumption within the state. So that potentially could be two. Does that
Yeah,
make
I
sense?
take your point, and it's an important one to emphasize. The way I read this, and I think the way it should be interpreted is that first clause, heating fuel into or in the state, that is designed to capture both actors who are providing fuel from out of state to someone inside the state.
Mhm.
And also to make sure it's not discriminatory to apply to someone who's wholly in the state
Mhm.
and selling in the state. But I think that last clause is equally important to be applied to both of those actors, the out of state and the in-state actor.
Mhm.
That it only applies to consumption within the state. So you don't want to be in a situation where, for example, someone's transporting heating fuel from New York to New Hampshire
Mhm.
with no delivery or use in the state
Right.
for consumption in the state. Then you would start to touch on the extraterritoriality concern. So we're regulating something that, but for traveling through our state and interstate commerce, doesn't directly impact our.
Okay, so I think what I'm just grammatically just like breaking down that sentence, what I'm understanding now is that it's the entity that makes the first sale of heating fuel into or in the state,
Yes.
right? So it's not the first sale into or in the state.
Yes,
Right,
I think that interpretation is correct, and that's how I would read this, but if there is a comma that's needed there someplace or, another, I think this has been pretty well vetted, and I would be comfortable with it as drafted, but if the committee thought there was a clarification to make that point clear, I don't think that would hurt.
A missing word too that feels to me like it's important. It's first sale, it doesn't say first retail sale.
Mhm. Yeah, it's
That-
first sale.
I think sometimes people would imagine it was a retail sale, but.
Well, I don't know that it has to be. I mean, I think if it's a wholesale sale,
Right.
this goes to my next point. I think for the efficiency of the program, it is ideally applied, the obligation is applied as far up the chain as possible.
Right.
So I think you would want to capture wholesale if it is intended for consumption in the state.
So I think I did speak very clearly.
Yeah.
That it includes whether you're making a retail sale or making a wholesale.
Sorry if I
Purchase.
misunderstood that. Yes.
I don't want to do like legal editing on the fly, right? Because that's never a good idea, but I'm just going to posit that it might be clearer if it makes the first sale into or the first sale in
Mm.
the state,
Mhm.
just to say it twice, just to be real clear. But anyway, I don't know, we can. Actually, thank you.
Yeah, absolutely. And so we just talked about the making it as far up the chain of delivery as possible. And the last one I want to touch on relates to federal preemption. I think, again, this is satisfied, but you do want to be clear that to the extent you're regulating a natural gas distribution utility, that is based at sales on the distribution level, not on their wholesale transactions, because that is regulated by the Natural Gas Act. And the way I read this here is a regulated natural gas entity serving customers in Vermont that's focused on its distribution to customers in Vermont.
So an out-of-state supplier selling wholesale gas to an in-state facility, vendor, Vermont Gas, I'll just name it.
Yeah, there's only one in the state.
There's only one.
Yeah.
Selling to Vermont Gas, that they are I'm just trying to distinguish why.
The obligation,
Obligation doesn't land on them as the wholesaler selling into.
the obligation there should be on the distribution utility because of the Natural Gas Act. So that you're not in that particular instance. And there are a number of cases speaking to the fact that you can regulate utilities in the state in a slightly different manner, but it should be on the distribution utility in that instance. So there's no question that the state is trying to regulate wholesale transactions of natural gas, which would be likely preempted.
So
So just thinking about somebody in a fuel dealer in Vermont. So they're trucking it in from Massachusetts or from Quebec, and so I just want to be clear, just to make sure that I understand. So the obligation is not on the Quebec company. It is on as the seller, or is it?
We have to be careful about what kind of fuel we're talking about. So the first clause here, I think, is only applying to natural gas that's being provided into the distribution system for a regulated utility. In the other instance, a propane provider, some other kind of gaseous product, I think it could be applied to the wholesaler as they bring it into the state for that sale into the state.
That Quebec company or the Massachusetts companies, and that would not violate.
Their sale is reaching into the state, and if that product is intended for use and consumption in the state, they could be subject to.
So that would not violate the dormant commerce clause.
No.
Okay, thank you.
one more quick scenario. So I think there, people have been trying to make sure they understand it. And I've talked to fuel dealers in the state who are buying from a wholesaler who's already brought fuel into the state. So does a fuel dealer in that case making a purchase from a Vermont wholesaler or a wholesale facility in the state of Vermont going to have an obligation under this bill?
I guess I want to think about the specifics of this scenario. It is the entity that is bringing the product into the state or in the state, consumption in the state. And so I think the important thing there would just be for the wholesaler and the retail provider to be clear about when the obligation applied. It may be the wholesaler who has the obligation and they're simply passing it through to the retailer. There might be scenarios where the retailer is purchasing something from a wholesaler who isn't complying. And in that case, I think you want to make sure that retailer is still complying with the statute.
So the line I've been trying to clarify for myself is if that wholesaler is in the state, the person who brought that fuel in already had an obligation.
Yes.
So the retailer picking it up no longer will not incur that obligation. If the wholesaler were located out of state and in-state vendor went out of state to purchase it,
Yes.
now that retailer is causing it to have they are going to be the source of a sale in Vermont. And that's when a retailer will pick up that obligation.
Yes, that is a
correct way to say
more
it?
eloquent response than I gave you. That is correct, Senator. Okay, so it's a short presentation. Hopefully I didn't take up too much time. I'm happy to answer other questions.
Great.
I'm gonna
We
just
welcome all opportunities
stop
to
sharing.
talk about the dormant commerce clause. We just don't have enough opportunity to do that in the course of the year.
Oh, shucks.
Thank you very much.
Thank you.
And Murphy, thank you for coming back again. So welcome to your review of the bill, any kind of feedback you want to provide us.
Great, well, thank you. Thanks for having me back again. It's good to be here. I'm Laura Murphy with the Attorney General's Office. I am the Director of the Environmental Protection Unit and an Assistant Attorney General. It's good to be here. So I think what I'll do is highlight a couple of the things that Jeff talked about with respect to the Dormant Commerce Clause, and specifically our thoughts on how it relates to this bill. And I just want to give the big lawyer caveat in the beginning. There are no guarantees in the courts of law, so this is based on our best assessment, and we agree with Jeff's assessment. But just caveat, we can't provide any guarantees about what a court will do or say. So with that caveat, I'll just start with, there's basically four categories of the Dormant Commerce Clause buckets, I'll call them. And the first is pretty straightforward. This is, and Jeff talked about all of these, but this is the facial discrimination bucket. So if the statute says on its face, if it distinguishes between in-state and out-of-state entities, there's going to be a problem, most likely. This statute does not do that. It applies equally to heating fuels, whatever state they come from, in-state, out-of-state. Similarly, it applies equally to clean heat measure providers. So a clean heat measure provider could be from in-state or out-of-state. There's no facial discrimination. An example of facial discrimination, there was a case in Michigan back in 2005 where Michigan passed a law that said out-of-state wineries cannot make direct shipments to homes in Michigan, but in-state wineries can. And obviously that was a problem, and that is not the case here. The next category is discriminatory purpose or effect. So this is where the face of the statute doesn't discriminate between in-state and out-of-state entities, but it is where the statute has the purpose or practical effect of favoring Vermont products over the same or similar products from other states. Again, this statute doesn't do that. There's no indication of any discriminatory purpose. It applies equally to, again, same thing, heating fuels from in-state or out-of-state, same thing with the clean heat measures. Just to give you an example of something that did have a discriminatory purpose or effect, even though it wasn't facially a problem, North Carolina adopted a regulation that basically said all apples sold in the state can only have the USDA label. Okay, fine. In-state apples, out-of-state apples all have to have the USDA label. The problem was that Washington State apparently had these wonderful, beautiful apples that had a very well-known grading system. And so Washington was no longer able to use that grading system, so consumers could no longer tell when they go to the store, oh yeah, this is a Washington apple, I want to buy it. And apparently, similar to what Jeff was talking about, there were some legislative statements in the record about wanting to protect North Carolina apple producers. So that would be an example. Again, in our assessment, that is not the case here with this bill. The other one is extraterritoriality, and this is really asking whether, again, the state law has the practical effect of requiring out-of-state commerce to be conducted at the state's direction for conduct that is wholly outside the state. So that, an example of that, it's a little bit complicated, but essentially Connecticut had passed a law requiring beer distributors, brewers, to make an affirmation that they would not charge higher prices in Connecticut than they did in any other state. Problem was that affirmation had to last for an entire month. So if the beer producer wanted to change the price in another state, they couldn't. Right. So again, just having effects upstream on commerce does not rise to the level of extraterritoriality. The state is, in our view, absolutely within its authority to regulate products that are sold and consumed in the state. Courts have held, again, that sort of these upstream impacts are not creating an extraterritorial effect. And again, I think with this bill, the obligated party definition that we just talked about applies to the first sale of heating fuel into, or the first sale of heating fuel in the state. I do believe that's the intent, for fuel that's used in the state. So the fact that it only applies to fuel that's used in the state should be enough to satisfy this issue. We also have the extra sort of assurance that it also only applies to the first sale essentially in the state. And so our analysis is that this bill is okay under the extraterritorial, I have struggled with this word, extraterritorial analysis. Let's see, so the pipe balancing test, this is the fourth bucket. This is, again, once you get to this place, if you're not having a discriminatory purpose or effect or facially discriminatory, courts typically uphold state laws under this balancing test. And it's really a question of whether, if there is a burden on interstate commerce, is it clearly excessive in relation to the local benefits? And again, here the analysis we believe would be that if there is a burden, it is not clearly excessive. The sales into Vermont are voluntary. There are various opportunities that companies have to earn credits, different ways that they can do that. And again, there are opportunities for companies to provide the clean heat measures themselves. So the burden, we think, is definitely not clearly excessive in relation to the local benefits, which are reducing the greenhouse gas emissions in Vermont, promoting more sustainable, low carbon, affordable heating solutions, and again, with the emphasis on equity, which is important. So any questions about the Dormant Commerce Clause?
I want to go back to that slightly slippery, where are you buying and who ends up with the obligation in different scenarios, especially. So if I'm a Vermont retail fuel dealer, actually if I'm a Vermont business that wants to buy heating fuel for sale in Vermont, and I go to an out-of-state company, maybe they're located someplace else, Portsmouth, New Hampshire, or whatever. Because I'm based in Vermont, will that wholesaler, even if they're selling to me regardless of whether I'm a wholesaler or retailer in Vermont, will they, as the seller, have an obligation to, will they become an obligated party?
My understanding is that yes, because the New Hampshire wholesaler is making, Jeff, tell me if you disagree, the first sale of the heating fuel into Vermont, essentially to this Vermont company, right? That's where the obligation would be.
Okay, we just wanted to chase it all the way down. And then the other distinguishing model was that if I'm a Vermont wholesaler and the fuel I have for resale to a local fuel dealer who does deliveries, I've already settled out that transaction. The obligation happened by the time I bought it in and set up my wholesale rack in Vermont, whatever it is. In other words, that transaction's already happened, wholesaler to wholesaler. It was a sale into Vermont, regardless of whether that was the end customer or it's going to go on in commerce.
Correct.
Got it.
Yes.
Thank you.
Yep.
Anyway.
Thank you, Chair Murray. And that's kind of where when you describe it like that, and then I hear your definition, it sounds like that would be not allowed. Because it would be implicating another state's organization. But you're telling us that that's fine under the definition that you have.
That's our assessment,
Okay.
yes. And it's because it's okay to have upstream effects on things as long as there's not an intent or an effect of helping Vermont businesses at the expense of out-of-state businesses, right?
Yes.
But if we think about it in terms of there are labeling laws, right, for food products that are sold in the state, mercury light bulbs, and this was a law that was upheld specifically under the extraterritorial analysis. I believe it was, I forget the year that it was, but Vermont passed a law requiring light bulbs to be labeled if they had mercury. It got challenged under the Dormant Commerce Clause. It was upheld. And part of what the plaintiffs were saying was, well, this is going to cost us more money in our, upstream and our out-of-state places. And the court said, no, these products are being sold in Vermont, and Vermont has an interest in ensuring that consumers have this information.
That is a fantastic example. Thank you.
So great.
Thank you.
All right, other questions on that one? Okay. Let's see, let's move on to, I did want to address the consumer protection piece of the bill. With a caveat, I am not an expert in consumer protection, but I have conferred with those who are. So we'll see what I can do. So basically, there's like, and this is new from the bill last year, I believe. There's a consumer protection section, which is, it's section 8128. And at least in the version, my version of the bill, it's on page 24.
And just so you know, we had some conversation about this already. And there was an interest in the part of the committee to ensure that consumers were protected. We were unsure. So we added language a little bit as a reminder / placeholder to make so that we would check in, and because we weren't clear as to whether or not existing law already covered the situations that might arise under the kind of commerce anticipated to happen out of this bill.
And that's very helpful. And our thought is that yes, in fact, we do have other law that already addresses this. So our view is that this section is actually not necessary. We have a Consumer Protection Act, as I'm sure you know, in Vermont, that we believe gives us the tools to address these types of concerns. So and this is in 9 VSA 2453. The Consumer Protection Act prohibits unfair methods of competition in commerce and unfair or deceptive acts or practices in commerce. And we think this covers things like predatory practices, fraudulent sales, lying in your sales pitch, and things like that. So this is something that's enforced by the Attorney General's office, and there would be a Consumer Protection Act case, and the remedies would include things like injunctions, like stop doing what you're doing or start telling the truth to customers. There could be civil penalties. There could be restitution, which is sort of giving back to the consumer what they've lost because of the deception. So we don't think a rulemaking is needed at this point. There are sort of two types of rules in this area. And one is where, for instance, with Vermont's labeling law for genetically engineered foods, which was requiring companies to put a disclosure on the food product, that is an instance where the companies really needed the information about upfront. Okay, what does the label have to look like? What exactly does it have to say? Where should it be on the package? Versus a rule that sort of tells the companies don't violate. So the law already exists. You can't be fraudulent in your sales. You can't deceive consumers. Anticipating what the bad acts might be to prohibit them, we think would be difficult. And so our thought would be, let's rely on our existing tools. If it becomes an issue, certainly an example is with the solar industry and renewable credits. There started to be complaints. They might go to the legislature. They might go to the Consumer Assistance Program. They might go to the press. If we start to see issues, then what we did with the solar was issue a guidance and say, hey, these are the things you can or can't say. Also can take enforcement and also potentially do a rule down the road. So that would be the thought on that section.
So I just want to be clear about what sections you think are unnecessary. So I assume we call this section 8128.
Yes.
Yes. Okay. So like A and B, but not including the severability. Like we should leave in severability.
Correct.
Okay. Okay. Great. That's just the whole thing.
Yep. Just A and B of 8128.
Okay.
That's right. And then I can address some of the Public Utility Commission's
Yes, please.
comments from yesterday. Okay. So, and I don't have the draft in front of me, but I know the commission had recommended some language. Oh, thank you. Okay, I appreciate that. Let's see.
Have it right here.
All right, let's see what page this is on.
And And, it's making, while you're looking for that
Yes.
place, it makes me think that when we get to a final draft bill or markup where we could with highlights of changes, I'd like to have the committee send you a copy of that, just to make sure that your evaluation of our status in the bill stays current right through the version that we here to vote out.
Sure.
Okay, thank you.
All right, so this is on page 14 of the PUC version, yes. So this is in the enforcement section of the bill. And it says, in addition to any other applicable penalties and remedies, failure to register with the commission is a per se violation of this section and the Consumer Protection Act. And the fact that you don't know is not a defense. So we would recommend some tweaks to this section, essentially, so that it would simply read, and happy to send this along later.
Yes, please.
Failure to register with the commission as required by this section shall be considered a violation of the Consumer Protection Act in 9 ASA Chapter 63. So that essentially it will make clear that if an entity fails to register as they're required to do, this is a violation of the Consumer Protection Act. There are other statutes that have similar features. One of them is regarding chemicals of high concern to children, which is in the health title. Essentially says a violation of this chapter is considered a violation of the Consumer Protection Act. That's where we got the language from. So we would recommend just doing that. We think it's already clear that if you fail to register, you're violating this section because it says entities shall register. So we don't think that part is necessary. Similarly, we don't think it's necessary to say that if you, just because you don't know you need to register is not a defense. That's already the case. One of the first things I learned in law school is that ignorance of the law is no defense, right? So it's already the case that unless it's provided that it is a defense, that just because you didn't know doesn't mean you didn't have to do it.
For the language you have, if you could send it to the committee and also to Mr. Kowski, who's our lawyer
Yes,
drafting,
certainly. Yep.
that'd be great. Thank you.
Okay.
Senator White.
Thank you, Chairman Bray. So one of the things that I am starting to understand with the PUC's process being quasi-judicial in their rate cases, my understanding was they wanted that language because of the way that they do their work. And I'm wondering, is there a difference in how their proceedings work? And does that make that language more helpful because of that? Or is it, they're the same across the board? Just trying, I feel like that if I was the PUC, that's the point I would make.
Well, that's a good question that I don't really know the answer to. I will say, again, this is just based on this reading, that since the statute says entities shall register, sorry, the bill,
Yeah.
entities shall register, and it also says the commission has the authority to enforce violations of this bill, that they should be covered. Now, if there's something I'm not aware of, that's possible. So, yeah.
So we will circulate your language suggestions back to them.
That sounds great. That would,
Okay,
sure.
thank you.
And then any other questions about that piece? And then one other thing I just wanted to flag, don't have a lot to say about it today, but I wanted to flag it for further consideration and happy to follow up if needed. This is at the bottom of pages, thank you for that.
Oh, yeah.
Bottom of page 12 onto page 13, and this is the version of the bill that's available on the website. So as introduced, it's again, this is in the enforcement section of the bill, 8124 G3. And this says that any statements or other representations made by obligated parties related to compliance with the clean heat standard are subject to the commission's enforcement authority, et cetera. This, just wanted to flag it for a consideration. It seems like it may not be necessary given the consumer protection piece that we already have, which is to protect against fraudulent and deceptive statements. If this piece is kept in here, I would recommend probably adding some more detail and clarity about what exactly the purpose of this is.
Senator Watson.
Excuse me, okay, so you're suggesting that we just get rid of 3.
I would say to think about it, and this, and I apologize, I wasn't able to connect with the commission about this before this morning, but I thinking it's probably not necessary.
Okay.
But again, of course, would recommend checking with the commission.
Okay.
And what comes after that is age, which is not a part, it's not under that, that's
Correct.
later. Okay. Thank you.
If you, in your language that you're sending over, so on the 8124 edit, if you can also note this and just explain briefly why you think it may be unnecessary. I know that some lawyers often speak more precisely than we do, so I would like to have you to be able to share your words with the PUC. Thank you.
Sure.
What?
This may be a more fundamental question, but is there a reason to not reiterate it here, even if it's already true?
I think not if it was just reiterating it. I think that would be fine. It might just be potentially extra language.
Yeah.
Part of this is, and again, the commission, I'm not sure if the commission added this language last year or not, but this seems to give the commission the authority to take enforcement actions against statements that clean heat measure providers make. And so if that is the intent, to give the commission the authority, I think it just needs to be sort of pinned down, like who should have that authority, and maybe it's both. If it is both, I would recommend more specifics about what type of statements are in fact prohibited, right? Because clearly it's not going to be every statement, so. Yeah.
So are you, if I'm hearing you right, it may be that this is too expensive.
It could be,
Yeah.
potentially.
Anything else that you want to flag for us in the bill or highlight?
Nothing else.
Okay, any other committee questions for Ms. Murphy? Thank you
Thank
for our legal hygiene session this morning. So it's good to clean things out. All right, so committee, we have, we're going to be starting, contrary to our, if you're looking at an agenda that's more than a day old, we were going to be breaking and starting at 10:30, we're going to be starting at 10:15. So with that, we will be on break for 15 minutes, 10:15, at which point we're going to pick up on examination of what kind of data the state of Vermont has around fuels and emissions. Who has that data? Who needs that data? What better data we might need? That's my teaser for coming back after the break.
Okay.
With that, we're on break.
Use the data.
Thank you again.
Thank you.
Thank you.
With pleasure.
First thing,
Wait, are we still live?
Just a wait. Sorry, I was trying to upload a document that was just sent to me.